Joining us now is Mr. Cliff Risman. Cliff is a partner and co-chair of the hospitality industry team in the Dallas office of Foley and Lardner. I could talk for a long time about Cliff's background and his credentials. When we think of a thought leader in the real estate, particularly when it comes to hospitality, resorts, franchising, management agreements, we really are speaking of Cliff. He would be the poster child for thought leaders in that space. As you can see, his clients and chambers describe him not only as the guru in this space, but he's also very practical and always accessible. He speaks the language. He understands this business better than most people I've ever met. Ladies and gentlemen, please welcome Mr. Cliff Risman.
Good morning, and thank you, Stephen. Last time I was called a poster child, it was for something completely different, but that's a whole nother story for another day. Some of you have heard bits and pieces of this presentation before. It's kind of a little bit of an accelerated HMA 101, but I'll do my best this morning to kind of weave in some more recent issues that have arisen as a result of COVID and what we've come through and coming out of COVID, and how different parties to agreements have reacted to that situation. These concepts apply to, all of them apply to lodging, but the vast majority of them also apply to food and beverage venues and any other venue that is managed by a party different than that party who owns it. So let's kind of start big picture. How are these arrangements normally structured? And the typical structure, as most of y'all know, at least domestically, it's a little different when you do things offshore, is a management contract where essentially the manager operates as the agent and for the benefit of the owner that retains them, and they receive fees, base fees, incentive fees that we'll talk about in a moment, sometimes accounting fees, different fees, but the bottom line is those fees come off the top out of the revenues, and the net results of the operations after those fees belong to the owner. And that's obviously somewhat of a different economic structure than if you had a lease, which you'll see from time to time for different reasons, although hotel leases are certainly historically have been more popular in Europe and offshore. And that's like any other lease where the tenant pays rent and then the net benefit or loss of the operations inures to the tenant. But everything we're going to talk about today is primarily with respect to management contracts. And the next thing I want to talk about is it's so competitive out there in terms of managers, branded managers, and others trying to win contracts. Virtually all of them endeavor to use their balance sheet in one form or another to get a contract as opposed to it going to their competitors. And you know that can be anything from an equity investment in ownership, whether it's common equity, some sort of preferred equity that's quasi-debt, whether it's debt, secured, unsecured, a junior mortgage. Many times, not many times, but often you'll see in order to win a deal, an operator will provide some form of operating deficit guarantee, where in essence they're using their balance sheet to guarantee certain returns to ownership. And if those returns aren't met, there's a make whole or a payment from the manager to the owner. And you know, those payments will normally have an annual cap, an aggregate cap, what their exposure might be. There are issues about, do those payments get, in essence, paid back to the manager out of future profits? Are they paid back with some form of return like interest? But the most common situation that's not up on the sheet is really key money, which is, I would characterize as a loan. but it's a loan that does not get repaid if the manager gets the benefit of their bargain, that they've bought a contract where they're supposed to receive fees for a specified number of years, and that key money investment amortizes usually on a straight line over the term of the contract. And so if it's a 10-year deal and the manager gets 10 years worth of fees without the owner terminating or otherwise defaulting, then the key money never gets paid back. The bottom line here is kind of the age-old adage that there's no such thing as a free lunch. When a manager or an operator uses their balance sheet, funds key money, at the end of the day, they will typically trade harder on the terms of the contract, particularly as to termination-related matters. But you know, the deal still has to pencil out. And if they're putting money in, they've got to get enough money out projected over the term to meet their return hurdles. So it all kind of gets factored into the equation. And you know, one thing I'll mention, I thought I skipped the slide, but these operating deficit guarantees that I talk about can be tremendously complicated. I'm actually involved in a dispute now where an operator provided an operating deficit guarantee, and along came COVID, and a major hotel in a major urban area was closed for a significant period of time, obviously triggering the operating deficit guarantee subject to the force majeure provision. And there is a significant dispute with a very lot of money at stake as to whether that particular force majeure provision trumped the operating deficit guarantee or not. And that will be handled in a private arbitration, but I'm sure there are a significant number of matters similar to that. We'll talk a little bit about fees. You know, the term you hear all the time, the buzzword, is alignment. You know, all the consultants say everybody wants to be aligned. Has COVID caused that to be even more so the case? Probably. But typically these agreements provide for some form of base fee and some form of incentive fee. And the significant difference being the base fee comes off the top. It's typically a percentage of gross revenues, whether ownership's making money, losing money, whether it's 3% of gross or plus or minus. The fee that people will say creates more alignment is the incentive fee, because that fee is typically calculated either off of EBITDA less reserves, which essentially is the equivalent of NOI or net operating income, or it might be calculated off of GOP, but there's normally some function of profitability that must be obtained for the manager to receive an incentive fee. And oftentimes those fees will have hurdles, whether it's a return on equity or return on investment, a specific dollar amount of cash that's been agreed upon, and the operator will only participate above that. And, you know, from the perspective of alignment, I guess people would say a lower base fee and loading more in the incentive fee would create more alignment. The one thing that's transpired over the last couple of years, particularly as hotels have either had very little gross revenue or in fact no revenue when they were closed during the pandemic, was you had managers with continuing ongoing management responsibilities and no base fee because there was no gross revenue. And so on the fee side, if anything has come out of COVID, I would say it's the concept of minimum base fees, regardless of what gross revenues might be, a specified dollar amount per month. So the management company's receiving some compensation even when a hotel is closed and not generating any revenue. I want to talk a little bit about termination issues. And for starters, as I'm sure virtually all of you know, the law is fairly well settled and has been for a long time, other than a few outlier cases, that a management contract in the context of a hotel or a restaurant is an agency agreement. Whether it says the manager is an independent contractor or whether it says it's a personal service, it doesn't matter what it says. It's an agreement of principal and agency. And so what that means is that under the common law, a principal has the power to terminate an agent, regardless of what the contract might or might not say. Absent certain specific circumstances, an agency coupled with an interest, which I don't want to get down in the weeds, but if the agent makes an investment in the principal, key money, equity, like we talked about before, if the investment is made simultaneously with entering into the contract and the investment is a not insubstantial amount and there is identity of the parties, it's not some affiliate writing the check, you might have an agency coupled with an interest. But outside that, it's an agency agreement. And what that means is the owner has the power under the law to terminate the manager anytime they want. Now, that's a very different issue than was the termination justified or was it wrongful? And if it's wrongful, there's a damage remedy. But the point being, an agent should not be able, in a properly presented case, to seek specific performance of a management contract. Can't go to court and have the judge tell the owner, you've got to let this manager run your asset. The one other thing I want to talk about in terms of termination is performance termination, because this is really something where the pandemic wreaked havoc. Typically, these are provisions where, regardless of where the parties are in the term of the agreement, if certain performance metrics aren't achieved, the owner has a termination right. Normally in the hotel context, managers will try and obtain, and generally do, two-prong tests that look at multiple years, normally 2 consecutive years, sometimes 2 out of 3 years. But did the hotel achieve, one, the cash returns it was supposed to, whether it's a test that's tied to budget? Did you have a certain percentage of the GOP that was budgeted? Is it a specific dollar amount of cash hurdle as opposed to the budget, as owners would prefer? And then there's usually a second prong as well, the RevPAR test. Bottom line, how did you do against your competition? Because if the market tanked and you missed the cash test, but you were doing as well as your competitors, manager's side of that story is you shouldn't be able to terminate me. Where this really plays out is how did and does force majeure play into performance tests? And I think the best answer is it sort of depends on how the force majeure language was written. You know, at the end of the day, the courts are all over the place. You know, we look at New York law a lot. New York has really not favored the force majeure argument in terms of managers and or tenants performing under contracts. But the more specific the force, and this goes well beyond this presentation, but the more specific the force majeure provision, those that had the forethought to specifically talk about pandemics and health emergencies and governmentally mandated closures and restrictions, you know, I think those people are far better suited to make a force majeure argument as to whether their 2020 or 2021 results that are being measured should be either equitably adjusted for force majeure if the contract provided for equitable adjustment, or even the test be waived if the contract provided for waiver of the test as opposed to equitable adjustment. I want to talk a little bit about financing matters. And look, throughout the pandemic and as we've come out of it, it's all been about cash. Lenders' desire to control cash. Owners' desire to use that cash, whether it's to pay debt service, to pay operating expenses, you know, CapEx obligations being deferred or waived, brand standards being waived, because everybody was trying to glom onto cash when there were little to no revenues. Layer on top of that incremental expenditures, and they may not sound monumental, but employee training over new health and safety matters, new cleanliness standards, modifications to your physical structure resulting from COVID-related matters. These all cost more money, and people dipped into reserves that had been specified for other purposes, obtained waivers from their brands of complying with brand standards, moratoriums on debt service. And what this all comes down to was it for a true waiver and it never needs to be paid back, or the reserve doesn't need to be replenished? Or was it forbearance and we'll give you some time, but eventually the interest has to be caught up, the reserve has to be topped off as we come out of COVID? And every arrangement was different, but that's kind of where people were focusing their time and attention. Labor issues, Andrea discussed at length the issues with finding and keeping employees. I'm not going to go into that. On domestic management contracts, the majority of these agreements provide that the manager is the legal employer as opposed to the owner. There are a whole variety of reasons for that. The owner usually does not want to be the employer, wants to try and avoid being a joint employer for labor law purposes. Yet at the end of the day, the owner bears the cost of hiring, compensating these employees, and they do try and get some modicum of control, even if it's consent rights as to the hiring of the general manager, the chief financial officer, things of that nature. Agreements that are offshore, it gets turned on its head for a variety of reasons. Typically, when you leave the United States, the owner is actually the employer as opposed to the manager. And look, the getting people back to work has been exhausted. So I'll skip over that. I want to talk just a little bit as we near the end of my time before the question and answers. Is kind of where things are going as a result of what people have learned and experienced through COVID. We see a world where the proliferation of different brands continues. Each one of these brands, in theory, is something marginally different, has some different standards than the others. Everybody has an opinion if that's really accurate or not, but it costs a lot of money to adhere to the physical standards, to retrofit an asset when a brand changes, to make physical changes. And I think people have learned a lot about whether all of those expenses are truly necessary, whether they can be deferred or not, because cash was king throughout, the pandemic. I think people have learned some things about territorial protection, and in the context of non-branded assets. I mean, look, we have some management company clients that would tell you, you would rather have me manage the asset down the street as opposed to try and prohibit me from managing that asset. Because if they're different brands and they're not competing, I bring economies of scale to the table. I'm not here as a business matter to tell you who's right and who's wrong, but I think views of territorial protections have changed. There have been some IP issues that relate to brand proliferation. But I think it is a different landscape. A lot of lessons have been learned, but at the end of the day, the vast majority of them relate to use of cash and employment matters and health and safety matters. And With that, happy to open it up for questions, Stephen.
Thank you. That was good stuff, as always. I have a quick question around, you mentioned the IP and you know, we've talked for a long time now that data has become so valuable, right? In your experience now, and I'm sure it's negotiated between the owners and the management group, who ends up owning the data at the end of the day?
Well,
Enlighten us, please.
There's a couple of things about data. I'm not a privacy expert or a data expert, but those of you who followed know about the European regulations that were put in place within the last several years, that being followed in California. You know, over the last couple of years, a lot of the folks who play in this space have struggled to figure out what that means, be compliant with all those regulations as to how data is maintained and stored. There's an issue about, do management companies actually ever possess or control this data when they're non-branded management companies? Some would say they do, some would say they do not. But if you're talking about guest data, at the end of the day, look, different people are going to take different positions. The brands have their views. Generally speaking, I think the mutual détente that has been reached by most reasonable people who practice in this area is that that data is owned by the brand, but it is licensed to the asset and the hotel owner for use at that asset during the time that the brand is on that hotel. You know, what gets left behind at the end, you see it all over the map. You know, most owners will say, subject to privacy regulations, you should at least leave me the information about who stayed at my hotel and where I can find them for marketing and future business purposes. You know, I don't necessarily need to know if your notes indicate that John Smith likes 2 olives in his martini and a fellow feather pillow, but I have a right to know who stayed in my hotel and where I can find them once you're gone. But that comes out all over the map.
And so is it the same kind of thing, Cliff? I know we're talking about the guests and you're talking about the guest affinity programs, that data, but what about all of our potential meeting clients? That's big business, right? And that management company has invested enormous amounts of time and energy into cultivating those business contacts. Who walks away with that? Because if I'm the owner, I'm going to argue it's mine because I'm paying, you know, but if I'm the management company, I'm going to argue the other side.
I mean, there's really no right and wrong, but the meeting business, in my experience, is generally generated through the group sales and marketing folks who typically are either with the management company or even with the brand. But some hotels have that in-house as the staff that does it is in-house. But that meeting business, you know, if you talk to any of the major brands without naming names, they'll tell you, those are our clients, those are our customers. When this contract is over, I'm going to take them to my new XYZ hotel down the beach. But some very sophisticated owners would take a contrary position. I will say this, and since you bring up group meetings, that's the part of the business that was clearly hurt the worst and is the slowest to recover. The luxury assets, you know, is more business than legal, but based on what we see with our clients, they're busy, they're rebounding, their valuations are back, particularly drive to luxury. Same with the extended stay product for a variety of reasons. But if you're in the middle of the food chain and you're a 4-star big box meeting hotel that relies on group business, and we all know who those brands are, I think they have been and will continue to be the slowest to come back from the downturn.
Rob, I'm not going to blow your cover, Mr. Schnitz, but are you seeing the business meetings bounce back pretty significantly? Or is it still mostly leisure, business travel, business meetings? Yep, seeing that. Yeah, okay. Chuck?
Yeah, I've got a question, Cliff, surrounding brand standards and particularly during the depths of COVID. I mean, we all know that, most of us know that there was a relaxation, specifically around CapEx. And what are you guys seeing now in terms of, are those now being reinstituted and enforced, or where's the CapEx issue?
I mean, my sense is it's a process, and the brands are in the process of enforcing them and reinstituting them. And I think, look, it's hard to say. Most of our work is on the ownership side, even though we do represent a number of management companies, but they're typically not the branded management companies. But our sense is it's a little bit asset by asset, and the brands are smart people, and when they see revenues up and cash being generated, they're trying to get back to where they wanted to be, to have their standards enforced. Those assets that are still suffering, unless ownership is going to pump cash into them, I think the brands have been more understanding, and it will take longer. I don't know that there's a one size fits all answer, Chuck.
We're just about out of time, but I want to leave the management and ownership groups. Oh, actually, I do have a quick question for you. And I think we've talked about this before, but I think the audience would be interested in hearing this. You mentioned about the ownership retaining the consent right on certain positions, right? And so in some of the litigation that we've seen, the plaintiff's lawyers will use that to keep the ownership group in the case. I'm just curious, are you seeing that a lot still, or has that backed off a little bit because owners have been kept in because they retain the consent over really the veto power, right, over the key positions?
Well, veto power is a relative term. I'll defer to the labor lawyers and the litigators on what's going on in the litigation world. But I will say this, my sense is when owners have been thoughtful and careful about their right to review and approve the hiring of certain members of the executive committee, typically a GM, director of finance. Sometimes in bigger assets, you might pick up the most senior F&B person, the most senior sales and marketing or engineering person. It just depends. But not when they don't have the ability to dictate who gets hired, but they really just have an interview right, an approval right. If they disapprove someone, they look at another candidate. Sometimes after they've rejected 3, the manager has the right to mandate who fills the position. Those properly crafted provisions, in my experience, have worked for ownership and not caused them to either be deemed a joint employer or dragged into litigation. But I will tell you, these agreements are all over the map. And, you have the same issues when it comes to collective bargaining. Who's leading the negotiation? What role do the two parties have in owner and manager in working together? Who ultimately makes the final decision on approving a CBA, or how an asset reacts to an organizing effort? It's the same basket of issues.
Interesting. Okay, I'm going to leave everybody with a law school exam question. Are you ready? So we know that you've got ownership groups and you've got management companies, and the management company hypothetically manages hotels, let's say in downtown Houston, for 2 or 3 different ownership groups, but a common management company for all the hotels. And then they want to install a central sales and marketing team for all 4 of those hotels that are managed by the same management group, but owned by different people. Yeah. Does that violate the antitrust laws of the United States? And I'm not asking you to comment, Mr. Management.
Well, Stephen, I'll tell you this without answering your question. If it does, there are a number of brands that are have a significant problem.
That's what professors do. We sit around and we think about these things. Sorry, Rob. Thank you very much, Cliff.